Now, to deepen the discussion, I spoke to a senior legal practitioner who specializes in commercial litigation and arbitration. He has expertise on an extensive range of issues, including medical arbitration. I began by asking my guest, Mr. Chinedu Anaje, to give a brief background on the National Health Act.
The National Health Act is a national law. What I mean, a national law, an act passed by the National Assembly. Is a comprehensive act that is meant to govern or rather regulate the health sector, nationwide. Now, it was passed into law by presidential assent on 31st of October 2014 by the then President of Nigeria, His Excellency Goodluck Ebele Jonathan. So it was actually assented to in 2014, precisely October 31st. So, and before that, I'm not aware of any comprehensive law, national law, that regulates the health sector. So when that was passed, and as of today, that's the only act that regulates, the health sector nationally. Aside that, before now, you had what we call the National Health Insurance Scheme Act, which has been there more like, providing insurance for accessibility to health services, in Nigeria.
What would you say are the key provisions or the innovative provisions of that act?
If you look at the act, from a comprehensive perspective, it has very laudable and wonderful provisions, of which one of them was to maintain, the provisions of to recognize the provisions of the National Health Insurance Act, which, like I said before, guarantees access, citizens' access to health care. In addition to so many other things that the act itself has provided. Then it talks, there's also.
That's when you talk about access to healthcare, that is the HMOs as we now know them.
Yes, the HMOs. Although there's, probably maybe we'll still come to that. There's also a downside to it. But generally, what the act seeks to do is to provide a framework, all right, for the regulation of the health sector in Nigeria by ensuring, in terms of structure, in terms of equipment, and in terms of services, being rendered within the sector.
Now, there's been a recent move by the lawmakers to amend some of the provisions of that act. Give us some background info about that. Okay,
from what I know, in the past couple of months, there have been this debate on the floor of the House of Reps, with respect to amending some provisions of the act, of which so there's about 7 of them, but the one that that has caught the eye of the public is the one that seeks to restrain public officers from accessing foreign medical attention or medical services. Now, what that seeks to do primarily is to limit, because if you read the provisions of the amendment, it's not saying that as a public officer that you should not, you cannot access medical services outside the shores of Nigeria. But what it tries to do is to put some checks and balances in place to ensure that before you access, medical attention abroad, it must be on the basis of need. It must be on need basis. All right. So what that means is that if you have a medical condition that ordinarily cannot be treated, in Nigeria by virtue of the hospitals and facilities that we have, then you make a case for yourself as to the reason you need to do that abroad. So that's basically what one of the amendments seeks to achieve.
The argument in some quarters that regulating international trips for medical treatment for public office holders would infringe on their fundamental rights to access the best Medicare, especially if they can afford it. Where do you stand on that debate?
From what I read concerning the amendments, the amendment is not seeking to bar you completely as a public officer from accessing medical attention or medical services outside the shores of the country. So what the amendment seeks to do is to ensure that it must be on need basis. In other words, there must be genuine case for you to say, as a public officer, you want to seek medical attention outside the shores of this country. Now, I tell you why this is. So it's because as a public officer, as much as you probably may have your money, all right, to say you want to use your money, what about the time? What about the time? Because in the past, the case has been, public officers, even if they have headache, the next thing they book flight, make arrangement to hospitals abroad, at whose expense? At the expense of the taxpayers' money. That is one angle to it. Then secondly, the other angle is in terms of time being wasted. A whole lot of them, they go out, they stay beyond the period approved for them. And sometimes these approvals are even given to themselves by themselves. All right? So you found out that in order to block those two leakages, that's why the amendment is coming. And to be frank with you, I think I support the amendment 100%. All right? Now, the amendment does not seek to bar public officers from accessing medical services abroad. That must be, it must be clear to everybody. What the amendment seeks to do is to put into place checks and balances. So, for you to access, there must be conditions that you have to meet. So, if you have a medical condition that you have the expertise here in Nigeria, so why then go abroad?
Now, you've talked about some of the downsides of the HMOs. But what other provisions of the Act do you think that lawmakers should be focusing on with a view to amend?
Now, looking at it this way, let me first of all start with, I've looked at the entire Act, and I think it was a wonderful work, but then there are still some areas that we need to improve on, of which I believe that the amendment they are seeking to do may give opportunity for that. Now, one area is that I think we should have an act that is proactive in terms of managing the health sector. Now, what I mean by that is the world has gone beyond treatment, all right, to being preventive. In other words, why will you have to wait for the health condition to come before you start treating it? So we should be able to have, a system that recognizes the fact that the way the world is going in terms of managing health issues is that you actually try to prevent it, because it's cost effective to prevent it than treating it, right? But I don't see that in the Act. All right, so there should be provision for that. And how do they do that? By establishing research institutions, all right, that will give opportunity for researchers, all right, and scientists to work. So there you have a kind of knowledge-based pool, if I may use the word, all right, so that we are always ahead of any health challenge that we may have as a country, all right? So you do data collection of what the health challenges of citizens are. So you start working on them and try to improve, to ensure, to see that, look, if in future you have a possibility of this kind of health condition arising, so there's always already a provision. And that's why the Western world, or rather the developed world ahead of us, called the third world countries, because they are proactive, so they think ahead of their time, right? So trying to create an opportunity that will arrest any future circumstance, so that it doesn't just degenerate to, okay, it has arrived, let's start treating it. So that's one area I think the Act failed to recognize.